Hello there, welcome. This is the Disability Law Show. Good to have you along, hopefully for the entire half hour. John Scholes here, Tamar Agopian there as well. Disability lawyer at disabilityrights.ca. Always willing to talk to you. In fact, you should reach out with any questions you have for Tamar. Want to mention as well, consultations will not cost you a penny. Just make that phone call, 1-855-821-5900. Back it up with an email, help@disabilityrights.ca. as well. Okay, lots of stuff to get through in the show today. We got phone calls, we got emails, we got a main topic in the second segment, which will be this week. Tomorrow, what you need to know about insurer-recommended treatment. We will get to that. Lots of good stuff coming up here, so stick around for the entire thing. We always start off with the week that was, or something you want to open us up with, pal. What do you got?
So I want to dispel a notion that I hear still time and time again after all of these years about the idea that people are only entitled to 2 years of disability benefits, okay? Because this recently came up on a claim that I had on behalf of a client, and so let me give our viewers just the quick and dirty. These disability policies, 99% of the time, will pay you until you are 65 years old, folks, okay? So there's no such thing as, oh, well, I've reached the maximum after 2 years, and then I got cut off because they told me I wasn't entitled to any more benefit because I don't have any more coverage. That is entirely different and more often than not incorrect, because most policies have 2 tests to qualify that come in at the 2-year mark. Sometimes at the 1-year mark, but usually at the 2-year mark. And so they make it harder for you to continue getting your benefit after 2 years, but it doesn't mean that you're not entitled to it. But this came up for a client because she had one of those rare policies that had a cap of 5 years maximum, total, even with the change of definition. And so it could be that you have a limit or a maximum period that you actually have coverage for under your plan, but is rare, not that common, and I never want people to accept if that is what you're being told, that you've reached the maximum benefit period. John, I see this in so many letters, and people say, oh yeah, I've reached the maximum, so I guess there's nothing else I can do. And then they don't take any additional steps. They don't call anyone, they don't question the insurance company, they just simply assume that they have only 2 years of coverage. And I think what's problematic in my mind is that if that's the reason why, that if the insurance company led someone to believe that they only had 2 years of coverage, that's a problem for the insurance company. The insurers have a duty of good faith. They have to be transparent with you. They have to share with you whatever relevant information there is as to why they're cutting off your claim, why they've decided one thing or another. In fact, if you're being pointed to a certain part of your policy, like say my client's situation where she was never told that she only had 5 years of benefits available to her. She too was cut off at the 2-year mark and came to me, came to our firm, had actually seen one of our shows and said, you know, this doesn't seem right. And I said, you're absolutely right. We started the legal claim, and in that process, turned out that she was put into an option of coverage under her plan by her employer's group plan to limit what she was entitled to. Now look, we still settled her case. We still got a good result for her. Situation very, very different. But she had to take that step. And it actually took her a year to even contact our firm to actually take that positive step. So if you're getting a letter from your insurance company that says you have reached some kind of maximum benefit period, please don't hesitate to reach out to a disability lawyer, someone like myself or someone in our team. Get a copy of the letter, get a copy of your policy, and send it to us so we can actually look at it and double check. Because it could be the adjuster is wrong, could be they've misled you on your coverage, and maybe they're dressing up a denial by pointing to something technical that is not correct. Either way, John, I think the key takeaway really is that you want people to be encouraged to find out. You can't do anything unless you have information and knowledge. And in my mind, this is why we do these shows. This is why we have all of the tools that we have to our disposal and that we put out there for people, is because we want to take away these myths. We don't want people to think that just because the insurance company has said to them no, or that they're capped, or they're this, or that they're that, or not disabled, that that's necessarily the end of the line. Because the starting point is, are your doctors supporting that you can't work? Do you have a disability policy that's supposed to pay you? Okay, let's see what we can do with this and move the claim forward with a legal claim.
I think 2 things. Number one, the reason why this client of yours did not know this or was confusion, it was a workplace group policy. So I guarantee you, she didn't read it. And I'm not blaming her, because when I used to, before I was self-employed, I never read the insurance policy from my employer. I had no idea what it said. I mean, now I got nothing, so don't break a tibia, I'm in deep trouble. But there's that part of it. And then I think unless she's 63,
right,
bordering on 65, then the 2-year thing might come into play, which I think most policies are still around 65.
Absolutely.
Then there might be a shred of truth. But to your point, send it off, have you read it, because it's
100%.
completely erroneous what they're telling you, right?
Well, so here's the interesting thing. I'm seeing more and more the options to extend between age 65 and 70. So if you are reading your policy, and you always should, and you may have that option to extend, and look, this is broker insurance advice, folks, but when you are being put on a group plan by your employer, or if there are changes happening with your group plan, do read the fine print. And if you're not sure, ask questions. Because if you are expected to continue to work, or in your mind, you don't want to retire at 65, all the power to you, then you may want to have these extensions and riders and other things that are available out there to allow you to have that layer of protection until you turn 70. Okay? That's comment number one. And then I want to pick up what John was saying, which is you're absolutely right that when people are starting new jobs and they're looking at their policies, they're not really looking at it in the way that I think we look at it at the back end. And I get that. 100%. Hindsight is always 20/20. But then make those questions known. Try and understand what it is that your coverage is available for. Because I actually had a conversation with someone this week. She'd actually called me and said, you know, I was certain that when I signed up for my plan, I did all of the enhanced packages that I could. I got a cost of living adjustment added on. I paid the extra premium to get, 70% of my salary covered, not the typical 60 or 66% of my salary. And yet, when I was on long-term, my insurance company approved me on the basic plan. And so I saw one of your shows, and I realized that I think they had done it incorrectly. I inquired with the insurance company, and lo and behold, they send her a correction letter, John. And that's hundreds of dollars of difference when you've got the enhanced packages under these plans. And if you've got an insurance adjuster who's asleep at the wheel, you might not even be getting the correct amount.
You're not going to pursue it.
There's that too.
Right?
There's that too. And I think what's most unfortunate is that a lot of the time these issues only come up when we are actually involved.
Yep.
When there's a lawyer involved like ourselves, we've initiated the legal claim. It forces the insurance company and their lawyer to look at it, review the calculations, review the coverage, check with the employer, and then all of a sudden, oh, we underpaid this person, or this was the right amount, so on and so forth. And so the point of all of this is be informed, educate yourself, get the documents, get the details. Even if you're not sure, give us a call. We'll help you navigate through it, or talk to HR and make sure that you're getting the right coverage, right? But either way, then at least you're not in a position down the road, 5-10 years down the road, potentially where you're making a long-term disability claim and you're handcuffed by what you have coverage for, or perhaps some limits that your employer has opted you into that you weren't even aware of.
Online tool called pocketdisabilitylawyer.ca. Tell me about it. I know you're a fan.
Look, this is an add-on to the genius that was Lior with the...
That's high praise right there.
It is. Well, look, it's the pocket employment lawyer. That's how it started. And so we wanted something similar on the disability side because it is an excellent tool for people to find out information. It's simple, simply worded, no legal speak, drop-down menus. You can click yes, no, this, that, and just get some really basic information on whether or not you've got a basis for a claim for your disability matter. And if you want to speak to a lawyer afterwards, one of us, somebody on our team, you can click yes, and we'll reach out to you. But if not, you can just X out of your browser. It's completely anonymous, but at least then it's a starting point for people to get that information that they need to figure out, how do I navigate this with the insurance company?
We got time before we get into a break to grab a phone call from one of our radio shows. Again, disabilityrights.ca to find a station in your hood that carries our program. Here we go, Tamar, listen up.
My insurance company just cut me off after over 3 years. I've worked in the banking industry for decades. I've been treated for depression with medication and psychotherapy. Even the insurance company's assessor agreed with my doctors that I just can't work. But now the insurer is saying I can work in another occupation. I don't know how this is possible if I don't have any relevant experience or ability to work right now.
Yeah, well, at least he got 3 years out of it, not 2. Right?
Look, John, I mean, it's possible. He's saying to us, how is this possible? You're right, but it's not right. It's not correct, and it doesn't make sense. And so here are the key takeaways as I look at and listen to this caller's information. First and foremost, he's now been approved, most likely, past that 2-year mark that I was talking about at the top of our show. So it means that the insurance company would have had to do the analysis already on whether or not his health, the depression, and I'm assuming other health issues, but primarily mental health, if that already disables him sufficiently from performing other occupations, because that's really the test after that 2-year point. So onus is on the insurance company. They would have done that analysis, and they approved him for that. He's been approved past that 2-year point, and they've accepted, including the insurance company's own assessors, that he's totally disabled from any occupation. So what's happening now? When he has not improved, if nothing has changed, then the insurance company is not on good footing. Not only are they ignoring their own treatment provider, they're ignoring this individual's doctor's advice as well that he cannot work. And so when he's being cut off, this is where I see a perfect basis for a legal claim. This is where you want to assert your legal rights. The insurance company knows that they are probably not on good grounds, but what they bank on is that people won't do anything about it, that they won't move forward with their legal rights, that they won't hire a lawyer to fight this with the insurance company, and that they'll simply capitulate or sort of bow to what the insurance company wants, which is to pressure you back to some work setting, or at the very least cut you off and put the onus back on you, so to speak, to appeal. That's what they want you to do is, hey, justify to us after 3 years that you're still so sick that you cannot work, and we'll reconsider and we'll think about this. But that's the wrong way to think about it. The onus is on them, legally speaking, out of the gates to show that there's enough medical information to support this claim. So look, John, they're trying to shake him off claim. That's clear, right? And I think the challenge becomes, well, after 3 years, surely I should be approved until I'm 65. But these policies don't work that way because they are a month-to-month benefit. So for every month that the insurance company is releasing that LTD benefit, they need to have the medical justification that you meet their test of disability. And they get antsy, and they can probably project that he's not improving. Likely he's not getting any better with treatment. Likely nothing has changed. And their own doctors have said this to them. So why are they cutting him off, or why are they pressuring him off? Well, it's because they don't want to continue paying you. And at the bottom line is that if it's going to cost them more money to do so, they're going to find a reason to cut you off, and they're going to bank on the fact that you're not going to do anything about it. Hopefully this individual is going to give us a call and we can have an offline discussion about his options.
With that, we'll take a small break. When we come back, what you need to know about insurer-recommended treatment. That's on the other side as we continue the Disability Law Show. Stay with us. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you. They may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. Okay, welcome back. Disability Law Show. Thank you so much for sticking around through that wee break. I wanted to let you know that you can reach out to Tamar and her team anytime. Consultations will not cost you a penny. And if you have any other questions, same number, 1-855-821-5900, help@disabilityrights.ca. To get an email in there as well. Main topic time. We have one every week. And this week, a good one, Tamar. What you need to know about insurer-recommended treatment. Number one, insurance companies can suggest treatment or therapies, but you are not obligated to follow their advice. I don't know. Is that true?
It is true.
Okay.
I mean, it really is true. But they don't quite put it this way, right, John? I mean, I think, what people hear is They'll get a letter or a phone call saying, hey, look, what this great thing we're doing. Here's a rehab plan we've put in place for you, or we're going to do this great treatment option for you, and so on and so forth. And then what you end up hearing at the end of that is, they told me that I had to stop having treatment with my own therapist to see one of their therapists. They told me that I had to do this in order to continue receiving my disability benefit. So they force you to do certain treatment, but the policy doesn't actually allow them to do that. And so you want to try and understand, if your insurance company is calling you and saying, hey, you have to do this, understand what is it that they're asking you to do? How long is this so-called treatment going to be? Have they asked your doctors whether this is something that you should be doing? If they haven't, you want to talk to your own medical team. We're going to talk this through with our main topic today. But just out of the gates, just because the insurance company is saying you must, doesn't necessarily mean that you do. And so it's okay to get further information and to push back with your own medical team if it doesn't make sense to continue and follow their advice around what treatment that you need. Because the bottom line is, John, your own providers are the ones that care about you. They're the ones who actually want to see you get better and improve. And insurance companies like to insert themselves into your medical care for their own gain, their own advantage, because they want to have a provider that they're paying for to have them tell them you're good enough to work and therefore we can cut you off. Your own doctor is not going to be that biased. They're actually going to be looking at, can my patient actually work? Where are they from a treatment perspective? Can we actually do things to make him or her improve? And that really is the focus in terms of wanting to focus on your recovery with your own treatment provider's help, not the insurance companies.
It's like when you get in a car accident, the insurance company kind of recommends that you go to their garage to get it fixed. You know what, I'll do my own homework. Right?
Great example. That's exactly right.
Yeah.
And so if you know the insurance company is paying for that repair or this treatment, how one-sided is that going to be? Are they actually going to have your best interest at heart? Or are they going to be looking at what's cheap, what's easy, what's quick, what serves us best at that point?
Yeah. Point number 2, courts tend to give more weight to the opinions of treating physicians than to the insurer-appointed provider. Consistent medical history from your own doctor can carry much more weight than the insurers. I would say that's true, yeah?
Very true. And so let's unpack this a little bit, because there's a lot here. I think what our viewers may not necessarily appreciate is that there is actually a body of law where people have challenged their disability insurers and have gone before a court of law in Canada and have said, I have been improperly denied, and these are the reasons why I've been improperly denied. It's rare, but it has happened. And in those instances, I can assure you that in the vast majority of cases, the judges have preferred the own treating doctor, psychotherapist, physiotherapist over the hired gun of the insurance company. This is the weighting of evidence in the eyes of a court, because a court will get different medical opinions potentially about whether or not someone can work, and the judge or jury will have to decide, which do we prefer? And 99% of the time, they will prefer your own providers. So this goes back to the point I was making earlier, which is you want to engage your own medical team on where you're at from a health perspective, what's being recommended for your treatment, what's best for you. Because insurance companies are going to suggest to you that they know better, that if you just take this one pill, that's going to be the magic bullet, or mask your pain and you can work with pain, or you can manage with pain. I can give a million examples that are like this. But if a court were to look at this, they are not going to look at the insurance company's hired gun or their recommended treatment if it means that it's not sustainable, or you're actually not going to improve, or it's just a point in time in which they can then justify cutting you off. Bottom line is, the best treatment that you can get is one that you are either referred to by your own family doctor or one that you are accessing yourself and that you're paying for yourself.
Third point is this, Tamar, when it comes to what you need to know about insurer-recommended treatment. That is, if your disability benefits are threatened or denied for not following their advice, you can pursue legal action.
100%.
Yeah.
Right? 100% for exactly what I've already described, which is they may not be on good footing. They may not even, the insurance company may not even be using the policy wording correctly to suggest to you that you must follow their treatment plan. They want you to follow their treatment plan. They might even say to you, oh, the wait times are so long for the clinic that you're waiting for, so just go to our treatment provider. Folks, I've seen it all, okay? But I think the conclusion is that if your resistance to attending this treatment or doing recommended treatment is supported by your own medical team, then if the insurance company says you're not being compliant or you're not following our recommended treatment, and they cut you off on that basis, they are not on good footing. This is not something that they're going to be successful on. If they were to go to a court or a trial or a judge or what have you and say, hey, yeah, you know what, this is what we did to this poor disabled individual. You know, we made them do our treatment, and look, they were great after, 18 months, 2 years of being off. It was our treatment that magically made them better, and therefore we were justified in cutting you off. And John, we've been successful for so many clients on this kind of an issue, where either they lob, compliance, or they lob lack of treatment or what have you against my client, and I've still managed to get good results on their behalf, because I will use their own providers against the insurance company to say, hang on, you have one person who met my client 8 times saying they can work, and I've got the 20-year family doctor saying they've never been worse off, and this is, and you're using that to cut off the claim. I think I'm good, especially given what the body of law tells us about the weight of the evidence being preferred by the treating provider.
And by the way, when Tamar says she's seen it all, it's because she used to work for the insurance companies for years. So she's been behind the curtain of the all-powerful Oz, right? She's seen what ropes get pulled. I
have, and so I know what is persuasive to the insurer when it gets to the point where you've got that legal claim. But people have to take that step, John. They have to call us, have the free consultation, give us an opportunity to give you some advice and make some choices. Do not buckle to the pressure of the insurance company and what they're telling you, because otherwise, you're going to leave money on the table and not give yourself the best opportunity to either recover and get the compensation that you deserve.
All right, one more short break. We'll get to some viewer email on the other side. Stay with us. More of the Disability Law Show is on the way.
People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca.
Okay, a few minutes ago, welcome back. Disability Law Show. Reach out to Tamar anytime at the firm and have that phone call. Consultations are free as well. Want to throw that in there. And the phone number is 1-855-821-5900. Call it, no fear, no toll. Just use the number. Back it up with an email, help@disabilityrights.ca. That's where we're going to go for William. Says, guys, I've been on LTD for a year. Following my doctor's treatment plan, a few months ago, my insurer tried to force a gradual return to work program without consulting my physician and sent it straight to my employer. Shortly after, they claimed I no longer qualified for their definition of disability and gave me 2 options: go back to work or appeal, or I lose my benefits. What can I do now?
This is so frustrating to me, John, because this dovetails so nicely with everything we've been talking about on the show, which is, what can you do? Start the legal claim. It's very easy, because these 2 options are not real options. The option for you to appeal is, hey, pretty please, can you just look at my claim one more time, even though you guys got it wrong, but look at it again, and here's another note from my doctor that says the same thing. Look, it's not going to be successful, and you're going to be losing that time that you need, that precious time to focus on your recovery and be out of your funds, and have your LTD benefits end on an improper ground. I see this tactic a lot because it's really effective. People feel as though they really actually don't have any other choices, but they do have another choice, and that is to start that legal claim, especially if you've got that medical to back you up. And so what I actually don't like is they didn't consult with his own doctor, William's own doctor, before they made the decision to cut off his claim. John, that is quintessentially a problem where there's a breach of the duty of good faith, okay? The insurance company has not met their standards in having sufficient medical basis to cut off William. When they're putting blinders on and they're not actually contacting his doctors in order to get a sound basis for the cutoff, then already there's an avenue to pursue in that legal claim against the insurance company. And so what's the opposite contention? So they cut you off, you now appeal, you get another medical record from your doctor. Why will they care now in the appeal process? If
Same people.
Same people. Same people reviewing it, same decision making. They want to force that gradual return because that serves the insurance company. If you return back to work, they don't have to pay you. If you don't fight them, they don't have to pay you. Either way, they're not paying you. And what I'm saying is, get paid, William. Let's start that legal claim. Let's move forward, because I suspect his doctors are supportive and that this is just a hasty insurance adjuster who wants to just make their targets for the day.
It's like that appeal process Savannah always says. It's like your kid comes up and says, can I have an O. Henry bar for dinner? No, you cannot. So they come back in 5 minutes later. Can I have an O. Henry bar for dinner? No, you cannot.
Right.
You're going to get the same answer.
Same answer.
You know, most of the time anyway.
It's human nature. And I like the idea of thinking of it childlike, because a lot of these adjusters don't really have a lot of sophistication when they're looking at these claims. I mean, look, they are, entry-level jobs that they're doing for these insurance companies. They have a job to do, okay? And their job is to try and cut off as many claims as they can and find a reason to do that, and then tempt that carrot to say, oh, but convince us otherwise and tempt us with more information, and maybe we'll change our mind. But once that decision is made, they've already put your claim in a certain track. And it is very difficult to reverse that track if you're not actually asserting your legal rights.
Let's get to Jen very quickly. By the way, I would totally say yes to the O. Henry bar. Jen says, I've been on LTD for almost 2 years now. In the past few weeks, strangers have approached me outside my home, asking invasive questions about my life, my daily routine. After some back and forth, they admitted they work for the insurance company paying my benefits. This has seriously impacted my health and aggravated my PTSD. Is this kind of surveillance even allowed / legal, I guess is what she's asking.
Look, it does happen, John. Should it be done? No. When I see that she's got PTSD and that's part of her health profile, and the insurance company has now hired an investigator to actually engage with her, that's a real problem. And it's a real problem not only from a health perspective and a complete lack of sensitivity by the insurance company, but also the investigator should not be engaging you, right? And look, if someone is approaching you, I don't care if they tell you they're from the insurance company or not. You should be thinking of your safety as primary. I'm always very concerned when I hear about these kinds of interactions, because you should not be put in some kind of interrogation setting or being, essentially harassed on the street by some stranger telling you, even if they are doing so on behalf of the insurer, this is not correct. And in fact, I always get concerned about people, being followed and not sure and this kind of thing. Criminal safety, right? That's the number one thing. But very quickly to that is, this is actually not that common. If the insurance company is actually investing money in doing surveillance, it means they want to find something in order to actually cut off your claim. And so I think a lot of people do worry about surveillance to a high degree, naturally so, and I understand that. But insurance companies actually do it a lot less than you think. Right. The more common thing I see now is social media searches, and they comb through, and they have fake accounts, and they start to comb through and befriend you, or try and get pictures and take things out of context and use that as a basis to try and cut off these claims. Either way, it's not right. It shouldn't be done, but it does continue to happen. And so if information is being gathered this way and being relied upon by the insurance company, it's not correct, and it definitely opens the door to a good legal claim and some leverage against the insurance company.
1-855-821-5900. It's a free call. Call Tamar. Thanks. We'll join you next week.